Who have we got? Hi, Shama, can you hear me?
Hello.
Shama, nice to meet you. Let's give it a minute, shall we? Wait for other people to join, I hope, and then we will crack on. The other judge is Allah. Hi everybody, it's 11 o'clock. I hope you can hear me. I've got Shama, Layla and Yin Yu on the line, Jonathan. I don't know, I guess we're waiting for people from the other team, so I don't know if you're from Reading or from St. Joseph University. And we're waiting for the other judge, Ala, as well. But to be honest with you, I mean, if things delay, and I appreciate that people have got communication difficulties apparently, then I will, I think we just start in a few moments.
Excuse me. Hello, this is John speaking. I believe that my teammate, she has some difficulty into logging into this Zoom, and I have directed her how to do it, and I believe it would just take a few more minutes. So may you please just wait.
Yeah, Jonathan, that's absolutely fine. Yes, we'll just wait. let's give it to 11:05, Jonathan. Is that okay? And plus, Layla and Shama, are you waiting for anybody else?
No, we're the only ones representing St. Joseph University.
Yeah.
Great. That's great. We'll start in a few minutes. Then let's give it a few more minutes to see if Ala joins as well.
Yes, sure.
Hello. Teammate has just messaged me that after several attempts, she still cannot attend this call, and this situation has happened yesterday, and she has also reported to the IT person that she has emailed him, emailed the IT person. She did not receive any response as to leading today's inconvenience. I apologize.
That's okay. Jonathan, are you okay to do both sides of your team's advocacy then?
I believe so, but I will have to ask her for the materials because obviously I'm not taking in charge for ground of appeal as well. I've just have a brief idea of what's to be said, but I did not prepare it very detailedly.
Well, that's okay. To be perfectly honest, that's not a problem. If you've got a copy of your skeleton argument, then I think you'll probably be all right. I mean, just try your best. Which, Jonathan, are you from Reading?
Yes.
Ah, Shama
Oh,
says we can invite her to the meeting.
Fine.
Yes, hello. I think there's a way where you can actually invite her to the meeting or send her an email where she can access it.
Do you know how to do that?
Yeah, you just click on the participants below and then you can add someone to the meeting.
Jonathan, are you all right? Are you able to do that? Thanks, Natasha.
No problem.
Invite.
Yes, I believe so.
Yeah.
And I'm trying to do, yeah. Just send the invitation to join the meeting. So
Great, well done. Let's see if she joins. Jonathan, have you logged in through your mobile phone or through a computer?
I've logged in through the Outlook that is going according to the university's email.
Yes, so are you on a computer or your mobile phone?
My computer.
Okay, it's just
okay.
you've got slight wireless problems. There's a slight delay in speaking to you, that's all.
Yeah, I've noticed this problem as well, but hmm.
Did your teammate respond?
I've sent an invitation and the password to her, but she still hasn't responded yet. I believe signing in and using which email she going to use.
Sure. Well, look, I think we should start.
Yeah.
Now, am I right in thinking, though, that, I mean, I could ask St. Joseph to start, couldn't I, to be the appellant? Or is that, no, that's not quite right, is it? Can I just confirm, Shama and Layla, have you prepared to be, you're the respondents on the first ground and the appellants on the, sorry, the respondents on both grounds, is that right? On both jurisdiction and mistake?
Yes, we have prepared for that.
Okay, so you must be respondents. And then Jonathan, you're going to be the appellant on both grounds, are you, on jurisdiction and mistake?
Yeah, she has just messaged me that she has tried to log in through the invitation.
Okay, well, I'm afraid we're going to have to go ahead without her. So, Jonathan, what have you prepared? You are going to be the appellant.
Hello.
Yes, I've prepared.
Yeah, Suganda, yeah, go on.
I have prepared the.
Wait a second, Jonathan. Jonathan, wait a second.
Round of.
Wait a second, Jonathan. Suganda, yes, go on, yeah.
Yeah, hi. Actually, I think I can help you out with the person who is not able to join the meeting, your meeting. So I'll share the Zoom link over here in the chat, and you can invite your fellow members to join that link. Is that okay? You can just try, if they can join this link.
Yeah, please do it. Jonathan can send it. Yeah.
Okay.
Yeah,
Give it one more go.
I guess we can try.
And Jonathan, you're prepared to be the appellant. You've prepared ground 2, the mistake, have you?
Yes, I have.
There we go. Jonathan, if you can copy and send that link to your teammate. Any joy, Jonathan?
My teammate just messaged me that she cannot get to.
She can't get access. Okay, well, I'm afraid we're going to have to go ahead
My
without
apologies.
her.
She cannot access to it.
Then we're going to have to go ahead without her, I'm afraid. So, Jonathan, how would you like to divide your time?
So, yeah.
So, Jonathan, how would you like to divide your time?
Yeah. How much time do I have?
45 minutes.
How much time do I have? Can you refresh my memory?
45
minutes. Oh, 45
Okay.
minutes.
Yeah, 45.
Okay.
So my suggestion, Jonathan, is that you just crack on with the first grounds of appeal, okay? And I'll make due allowance for the facts that you didn't intend to be the senior counsel. So, Jonathan, yes, go ahead, please.
So, my name is Jonathan, and counsels on behalf of the appellant. So if the DIFC court have the jurisdiction under Article 5A on B, and as a reasonable trader under Article 437(1)(a) of the DIFC contract law, with the given circumstance that that a faulty has happened in the system of Cleverty, the online platform of selling and trading the cryptocurrency. So Cleverty is a digital platform for trades of cryptocurrency. Cleverty uses a distributed ledger to allow simultaneous access, which is hosted with hundreds of digital notes across a lot of countries, for which some of those are in Dubai. Under agreed normal terms and conditions, Ms. Payne and Mr. Rassi both used Cleverty to buy or sell cryptocurrency. And the online platform does not allow users with less than USD 50,000 USD. That's, you have to go over this amount, and then you can trade the cryptocurrency on the platform. So both Mr. Razzi and Ms. Payne have developed an algorithm to buy and sell the cryptocurrency, Yapple in this case. Alpha, which is the algorithm being produced by Mr. Razzi, is allowing him to buy the cryptocurrency at the best possible market price, and for Miss Payne is beta, and it sells the cryptocurrency at the most average price of the market. And it's notably to speak of the offer for Miss Payne is going to be an inflated price if there are no other sellers in the market. So after the routine update on 20th June, Cleverty, the platform has an error into setting the limits of selling and buying the cryptocurrency. The limit is 200,000. May I please refer to my facts?
Yes, please do. And if you want to, you can put your camera on as well. But if you don't, then
okay. So yes, the limit for the limit for the trading after the update, the routine update, that it is with the faulty system is $200,000, and the error has been in the system for just a minute before the glitch was detected and rectified. And in the online platform, there is only Mr. Razzi and Ms. Payne that their accounts have over $200 US. Therefore, as a result, the algorithm automatically conducted what they should have conducted, and Mr. Razzi, he sold 100 Yapples to Ms. Payne, which has inflated 250 times of the original market price, and therefore resulted to 200 and cryptocurrency. And these all happened when both of them are asleep. So after this brief facts, the first ground of appeal that I'm going to address is if the DIFC court has the jurisdiction to be involved in this case. So as I disclose, as I say about the Article 5 A1 of the digital instance shall have exclusive jurisdiction to hear and examine civil, commercial, or commercial claims and actions arising out of or relating to a contract or wholly concluded, finalized, or will be performed, or is supposed to be performed within the DIFC pursuant to express or implied terms stipulated in the contract. And obviously, as mentioned, the notes of the in Dubai, and therefore it grants the authority for the DIFC court to be the judicial authority for settling this trading dispute, and yes, so as the contract, as the whole trading, trading system of like on cleverity, it is based within the contract law of FC, and it so happened that for working for the system, it is eligible for the DIFC court to intercede into the matter. Sorry.
Okay, do you have any other submissions? That's great, Jonathan. Is that you're closed? Because then I can turn it over to St. Joseph.
Pardon? This is the first ground of appeal, yes.
Great. And St. Joseph, who, Leila or Shama, who's going to be who's going to answer this? Who's going
to? Me, I'm the senior respondent.
Great. Leila, you go ahead, please.
Yes. Your Honor, and may it please the court, my name is Leila Laisa, and I, together with my co-counsel, Ms. Shama Sawalhi, represent the respondent, Ms. Raz Rani. Would Your Honor like me to go over the relevant fact of this case?
No, get straight into your arguments.
Okay. Your Honor, the Court of First Instance rightfully concluded that the presence of one of Clavity's notes in the DIFC satisfied the conditions of Article 5A1B of the Judicial Authority Law. Now, Article 5A1B of the Judicial Authority Law states that civil or commercial claims and actions arising out of or relating to a contract or promised contract, whether partly or wholly concluded, finalized or performed within the DIFC, or will be performed, or is supposed to be performed within the DIFC, pursuant to express or implied terms stipulated in the contract. Now, Your Honor, the purpose of this article is to bring within the exclusive jurisdiction of the DIFC court claims that arise out of contracts where the connecting factors have been partly or wholly concluded in the DIFC. Now, when we're talking about connecting factors, what we mean by that are digital nodes. And in digital nodes, each node has a copy of the whole blockchain. So every transaction is known. And when a transaction occurs, the node creating the transaction broadcasts its details using encryption. So in brief, we can say that every node hosts, secures, and encrypts all the transactions done all over the world, including on the Clevity platform. That is my point towards the appellant.
Okay, great. Then, Leila, let's see. So you're upholding the initial first instance decision, and the point is that there are millions, not thousands, sorry, of nodes around the world, and it just so happens that one is in the DIFC, but we don't know if the disputed trade went through that server. It could have gone through that server. It could have gone through all of the servers on YAPL's framework frame. Or it may not have done at all. We just don't know because for the evidence, and the assumption is sort of that it did. Jonathan, actually, let me jump in there. Jonathan, could you propose an alternative venue? English law allows somebody to say that it's not a convenient forum to attend for the jurisdiction of the DIFC courts to be engaged. Can you propose another
I did not receive that very well because the repeat your question. Thank you.
Yeah, your internet's problematic. Could you suggest another court system or jurisdiction that might be more appropriate to hear this dispute rather than the DIFC courts?
I believe not, because as the legislation has said, that partly or wholly concluded within the DIFC, and it serves that when it is included into this legislation, then it is for it is what it is. And if speaking about it is better, because Ms. Payne, I believe, may I please reverse my facts again?
Mm-hmm. But Jonathan,
So,
you're arguing,
yes.
you are the appellant, you are saying that the court has made a mistake. It shouldn't be in the DIFC. Now, I think there's a dispute there somewhere between Miss Razi and Mr. Payne. And my question is, which other courts? Let me give you an example. I think Miss Razi is based in Dubai, and the Emirates of Dubai outside the DIFC, and Mr. Payne is based in Oman. So do you think that the Dubai courts or the Omani courts might be better as venues?
I think when determining about commercial disputes, like for example, in this case, trading disputes, I think Dubai would have a fairly more mature legal system as to handling these kinds of disputes, as it is one of the world's big financial centers. And when handling these kind of claims, the Dubai jurisdiction must have a comparatively more mature legal and case laws as well to refer for to get a better, a fairer and a better judgment at the end.
Okay, Leila.
Yes, Your Honor.
Cool. Now you say we uphold the first instance decision because of the wording of Article 5A1B. It's mandatory. It says that the exclusive jurisdiction, not optional jurisdiction, not you can go to Oman or you can go to the Dubai courts, if the contract well, the claim arises out of or relates to a contract, which it does. It's a claim for a unilateral mistake in the avoidance of the disputed trade. And that long 5A1B sentence refers to contracts which are wholly or partly performed by conduct or an event which took place within the DIFC. Now, English law has this idea that the Latin tag is de minimis. It's the idea that something has to happen beyond being just incidental. There has to be some substance to it. I mean, don't you think that the mere presence of one of many thousands of nodes in the DIFC falls beneath the threshold of being wholly or partly performed in the DIFC?
Actually, Your Honor, as I've said before, the nature of digital nodes or blockchain is that they all mirror each other. They all have a copy of the entire transaction, no matter where in the world. So that's why even having one digital node in the DIFC, it proves that the transaction has been partly, if not wholly, concluded in the DIFC. So just the presence of one digital node is enough to prove that the DIFC courts are competent to look over this case.
Okay, so effectively, not even was it partly performed, it was wholly performed, because it's a mirror copy of everything else that happens all around the world. Now, English law does allow a court to disapply its exclusive jurisdiction in certain cases. It's called forum non conveniens. It's this idea that the court has a break on its jurisdiction if it's more appropriate to litigate somewhere else. Now, in this case, Mr. Payne and Ms. Rani are going to be the only witnesses to this dispute. Neither of them are based in the DIFC. The documents that they might have in their disclosure, which they pass to each other, are also based outside the DIFC. Although it's assumed that DIFC law applies to this transaction, it might be that the standard terms and conditions that that the Cleverty use is not DIFC. So it might be that the contract and the disputed trade took place under an alternative law, maybe Dubai law or Omani law. Jonathan could well say that it would be more appropriate for the case to be heard in one of those two courts where the parties are based. What would your response be to that?
My response would be the same as I gave before. I mean, the presence of a digital node is really important, and it determines the competence of this court and how it should look over this case.
Okay, so I suppose you might say that all of the benefits of litigating in Dubai, outside of the DIFC, or in Oman, could be found in the DIFC courts anyway. They can apply the laws that are based elsewhere, and I don't think there'd be any inconvenience for the parties to turn up to the DIFC courts to have their dispute heard. Would you agree with that?
Actually, Your Honor, I have another point that aids my first point, which is a precedent of the DIFC court called Al-Khurafi versus Bank Sarasin. And this case raised a point that this court is given jurisdiction because there had been relevant activity. Now, what we mean by relative activity is that transactions related to DIFC mean that any incident or transaction should have been a result of a particular commercial activity carried out in the DIFC. And as I've said before, since each digital node is part of an overall transaction, we can say that the trade was partly, if not wholly, concluded within the DIFC. So this is another point that aids the first point I pointed out.
It does. It does. I think we are talking about a contract, aren't we? We're not talking about the incident ground. There's no tortious elements to this. Fine. Okay. Well then, Jonathan, shall we move on to the second ground of appeal, or do you want to take a 5-minute break?
I would like a break.
Okay. Well, look, it's 11:37. Let's restart then at 11:45. So just mute yourselves and turn your cameras off.
Yes.
And we'll start again in 8 minutes time. Shall we? Let's do it in 8 minutes. See you then.
Yes, thank you.
Hi, Jonathan. Do you want to go ahead?
Please give me a minute more. Thank you.
Sure, yeah.
Yeah, it will be quick.
Yes, go ahead, Jonathan.
Yes, so I'm going to address the second round of PU, which is regarding that the appellant finds the court's the finding that the finds a reasonable traitor with knowledge of the system surrounding the transaction. It is not sufficient for the purpose to satisfy Article 37(1)(a) of the DIFC contract law. To begin with, please let me disclose to you about what the Section 37(1)(a) of the contract law is. So it is about the relevant mistake in contract. So a party may only avoid a contract mistake if, when the contract was concluded, the mistake was of such importance that a reasonable person in the same situation as the party would not have concluded it at all if the true state of affairs had been known. And A, that's the other party made the same mistake or was also mistaken or caused a mistake or knew or ought to have known of the mistake, and it was contrary to reasonable commercial standards of fair dealing to leave the mistaken party in error, or the other party had not at the time of avoidance acted in reliance on the contract. However, a party may not avoid the contract if it was grossly negligent in committing the mistake, or the mistake relates to a matter in regard to which the risk of mistake was assumed, or having regard to the circumstances should be borne by the mistaken party. So my claim as to why the first instance court has erred in concluding that Ms. Rassi showed as a reasonable trader is because on comparative sense that Mr. Payne, when he has written his algorithm, he has set this safety net as to if or what a reasonable person, no, not Mr. Payne, Ms. Ratzi, written this program with a reasonable trader that would have thought of is if there are no other sellers in the market. This is where it comes to if one is being called as a reasonable trader, because when you trade, you as a reasonable and responsible businessman of that Circumstance that is reported in this case, which is if there is only a buyer and a seller, that's the seller, which is the algorithm in this case, which is Mr. Payne's or beta, that's it will automatically offers the cryptocurrency for a sale at a highly inflated price. However, when Ms. Razzi had written her program, she has only considered that when when it was in a group of sellers, that she considered this as the only factor into writing her program, that it is going to take the average price in the market, that she as a trader has not shown train of thought very cautiously. That's what if at the very utmost basis of trading that there is only one buyer and one seller, then what will her program do? As if it is taken into account that the average price of the market, then it is dominant by the only seller. So Ms. Rassi, in this sense, as in designing her program Alpha, she did not show that it is a very it did not show that she was a reasonable trader, because as I've mentioned, is that she should have thought of circumstance like Mr. Payne, who has offered. Yes.
Yeah, so 37.1 talks about the reasonable person in the same position as the party. So a reasonable person in the same situation as Ms. Razi. 37.1a is about the other party, Mr. Payne. So it's the other party, ... ought to have known of the mistake. What information do we take into account when we say that he ought to have known of the mistake? Do we say that when programming his software, he ought to have known of the mistake? Was it when he was asleep he ought to have known of the mistake? At what time and in what scenario do we say he ought to have known of the mistake, or not in your case?
I believe when both parties have signed in for this online platform, they ought to have foreseen that such mistake may have the possibility to happen. As it was being said, both parties know the normal terms and conditions of joining this online platform, which it was used as a distributed ledger, and this ledger is hosted across hundreds of digital nodes in many countries, and one of which is in the IFC. So when considering this, it is so diverse in the world that but the possibility of having a disruptive faulty in the system is more likely to happen compared to other online platforms. And as Mr. Payne has shown that he has indirectly take this into account, that if there is no other trader, then the algorithm will automatically offers at a very high inflated price. This showed that he has taken this reason into account, as he may have known such things will happen, and at this case, he's going to sell his the cryptocurrency Yapple as much as possible. So this has shown that Mr. Payne has put forward some sort of consideration. I will not say if it is sufficient, but at least he has shown consideration into the fluctuancy of the instability of this online platform, maybe.
Okay. Do you have any other submissions, Jonathan? Can I pass it over to Shanna?
I do not, thank you.
Shanna.
Yes, hello. May it please
Hello.
the court, I,
Yes.
Shammat Sawalhi, appear on behalf of the respondent, and I will begin with my second submission. This court should find in favor of my client for the following claim: that the disputed trade was in fact a result of an error, therefore the mistake does exist. With respect to the first point, Your Honor, the fact that the appellant has placed its sell orders for Yapple at a price which was inflated as a result of the intendedly programmed inflated price strategy effect. This indicates, Your Honor, that it is impossible to state that it couldn't have been operating under such an assumption. Hence, Mr. Payne knew and would have known that such consequence would arise in the future, and not just on my client, but even on any other users on the platform. With that being said, this is why my client's error was contrary to reasonable commercial standards of fair dealings. And according to Article 37(1)(a), which states that a party may only avoid a contract for mistake if, when the contract was concluded, that the mistake was of such importance that a reasonable person in the same situation as the party would not have concluded at all if the true state of affairs had been known, and the other party made the same mistake or was also mistaken or caused the mistake or knew or ought to have known of the mistake, and it was contrary to reasonable commercial standards of fair dealings to leave the mistaken party in error. This, Your Honor, proves for a fact that the disputed trade between my client and the appellant was in fact a result of a mistake. So it would be unreasonable clause to state that such mistake is disregarded, Your Honor, which was caused by the appellant. To further explain, mistakes can come in various types of forms, such as unilateral mistake in common law and unilateral mistake in equity. This has to be differentiated when truly analyzing unilateral mistake, whether it was operating at common law or at equity. Firstly, a common mistake is a mistake that can be shared between both parties. However, Your Honor, this is technically difficult. Now, the obstacle with that is how will it actually be proved? So with that being said, unilateral mistake in equity would be and should be a reasonable clause in this case. This is evidenced in the precedent Coin PTE Ltd versus B2C2 Ltd. And as quoted, the value of differentiated analysis of unilateral mistake operating both at common law and in equity. This enables the court to address in a circumstance-specific way situation where, for one reason or another, the parties objectively reach agreement on a contract which one party knows or ought to know differs in some fundamental respect from what the other party thinks or it means. Therefore, Your Honor, what my client knew is that she was trading Yapple at the best available market price and not at a highly available price. In addition, in a typical similar situation to this case, Your Honor, programmers in any online trading platform would have concluded an autonomous trading. This sheds the light on the principle of certainty of contracts. Now, despite that principle, the fact that the parties willingly used autonomous trading algorithm, as quoted as well by the President, Coin PTE Ltd versus B2C2 Ltd, there is nothing surprising, imperishable, or unworkable about a test which asks what any reasonable trader would have thought, given knowledge of the particular circumstances, whether the unknown activities of two computers in the middle of the night should bind the parties should be judged by asking whether any reasonable trader on the relevant exchange, knowing what was happening, could or would have thought in the otherwise prevailing circumstances. And this was anything other than the consequence of a gross and unintended major database breakdown. Therefore, the appellant is obliged to be asked whether he knew or could have predicted of the prevailing circumstances and if he intended the error. Nevertheless, Your Honor, in regards to the reasonable traders, any reasonable trader would not have conducted such transaction under the same circumstances. And lastly, Your Honor, my client has entered a disputed trade under a mistaken assumption that they were transacting at or around the going market rate of Yapple. This means that the appellant could not have been laboring under such an assumption, given that he had placed his sell orders for Yapple at an inflated price because he did intentionally pre-program the inflated price strategy, which therefore took effect. Hence, the appellant knew or ought to have known of the mistake, and it was contrary to reasonable commercial standards of affairs to leave the respondent in error. To conclude, Your Honor, for the foregoing reasons, we respectfully request the court to find in favor of the respondent that there was a mistake indeed caused by the disputed trade, and so hence the court could take whatever action is specified.
Thanks, Gemma. Well done for trying to get to grips with B2C2. It's a really hard judgment. It's a really difficult question. That said, you say that it is unfair. Well, let's put it this way. Obviously, Mr. Payne is going to say that he ought never to have known about the weird circumstances that led to the disrupted trade, the disputed trade. He says he created a piece of software that was just going to play the market whatever happened. Now, the judge in the first instance and the majority of the Singapore Court of Appeal in the B2C2 case, they said, well, that's fine. Let's look at what he ought to have known. He, as a person, he the programmer in that case, a man called Mr. Boonen. And there it said, well, Mr. Boonen didn't program his piece of software with knowing that there would be these mistakes. Now, similarly, there's no evidence that Mr. Payne programmed his piece of software anticipating that the sorts of weird situations that led to the disputed trade would arise. So isn't it a bit unfair that we're now holding him to a higher standard? We're saying that, well, okay, he may not, but we're going to change it to what a reasonable person in that position ought to have known, which is, oh, actually, this would be unfair if it was abnormal trading. Isn't that changing the goalposts?
Your Honor, could you perhaps rephrase your question?
Sure. The question is, in the unilateral mistake doctrine, we know that Ms. Rousey says she's made a mistake. It's fine. The question is whether Mr. Payne ought to have known that in the disputed trade circumstances, she made a mistake. He says that his computer software didn't know that a mistake was being made when the disputed trade was entered into. Your success in the first instance, the appeal point you're protecting, is that you don't need to ask what Mr. Payne thought when he was programming his software. You just ask, what's the overall circumstances of the case? Isn't that unfair? Aren't we now unpicking what Mr. Payne thought when he was programming his software? You still there?
Yes, Your Honor. However, I mean, his program was programmed to sell at a highly inflated price. So even if at the time he didn't intentionally or he couldn't have known of the mistake that would arise beforehand when he programmed his program, he should have assumed all the possible risk that would arise.
He should have. Oh, cool. That's pretty mean. There's a lot for him to take into account. It's a really difficult moot problem, this second round of appeal.
Yeah.
Mr. Jonathan, is there anything you would like to say at the end?
Yes. For clarification as to the junior counsel has mentioned that that his algorithm, that he have intended or ought to have known that such mistake is going to happen, but or have intended for such mistakes to happen as well. But Mr. Payne's intention as to designing this function into his algorithm is to protect, not to protect, but to earn as much as possible of his benefits in different circumstances. That's a reasonable trader or a reasonable businessman will do. It does not matter as into if he ought to have known that this mistake will happen or not. It's just a safety net, or put it in this way, is a chance for him to earn as much as he can, and therefore you cannot say that he has intended this mistake to happen, because he's a lucky guy that he has put his bets into this functioning of the algorithm, and it so happened that this did happen. Mistake, the error in the system. Can we say that patience and he cannot be rewarded into his cautions? I believe not so. So yes, that would be all for me. Thank you.
Excellent. Thanks very much, everybody. Well done. And I hope you enjoy the rest of the moot. That's great. Thanks very much, everybody.
Thank you.
Thank you,
Your Honor, you
Honor.
asked me earlier what made us sure that the JIFC had jurisdiction. Is it possible to confirm our position with one other point?
Yeah, go on. Yes.
Yeah, so there is a common law jurisdiction precedent called In Reteso security litigation, and it is one of the first precedents that took into consideration the physical location of the nodes to be relevant for jurisdictional analysis. And we've attached this in our court bundle as well, but I thought it would be important to point out.
Okay, excellent. Great. Well, thank you very much for that. Well done for bringing that up at the very end. Great. Well, I'll look off and enjoy the rest of the competition.
Thank you so much.
Thank you.
Thank you, Your Honor.
Thanks.
Bye-bye.
Bye-bye.